Hello, and thank you for joining us for the Ask Andrew Show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein, and I'm the principal of Feldstein Family Law Group, a law firm practicing exclusively in the area of family law. And we have offices in Markham, Vaughan, Oakville, and Mississauga. Both myself and our entire team, as I said, practice exclusively family law. And today I have one of our associates, Anna Troitschanski. Welcome to the show, Anna.
Thank you for having me, Andrew. Nice to be back.
All right, so let's start. Today's show is about common law couples, and I know it's a topic that you're familiar with. And I wanted to ask, can you start by telling viewers how long, because this is one of the questions I always get, how long do people have to be together to be viewed as common law?
Right. So there are two two definitions that can be applied to that. So you either have to be living together in a conjugal relationship for at least 3 years, or if you have a child together by birth or adoption, then there just needs to be a relationship of some permanence, and which does not necessarily require a 3-year duration. Now, a conjugal relationship is more than just a sexual relationship in Canada. A conjugal relationship is one in which two people share a home, finances, a same group of friends, and an emotional connection in addition to having a sexual relationship. So it's a very clear definition of what is required there.
Now, it's interesting because you talked about it from the some permanence, but one of the things that I think people have a misconception over is when they think about what is living together, because the normal thought process is to say, okay, I'm not living with somebody until they pack up their belongings, they get a U-Haul, or they rent a moving truck, or we move into a house, and we have this decision to actually move in together. Because we've seen cases where that definition seems to get extended to things where people really didn't think they're living together, and 20 years later, a couple that had separate homes breaks up, and one of them now says, I want to make a claim against the other one. I want to ask you for money. I know those are things that we talk with people about is a possibility. And for those viewers out there who are watching and maybe dating someone in a relationship that's been going on for several years, maybe I'm doing this less as a question for you, but more as a statement, you should be very, very concerned that the more indicia that you have of being a couple, more the possibility of you actually being considered common law. And you could be if you're spending even 3-4 nights a week together. I see you nodding, so I'd love for you to join in and give me your thoughts on that.
Yes, that's right. I mean, there are several factors that a court will consider when we talk about this relationship of some permanence. And you are absolutely correct in the fact that living together continuously is just one of the things that the court will look at. The court will look at various other factors, such as do the parties what are their lifestyles like? What are the various habits that they share, their social interactions? Are they financially supporting one another? And how are they seen by the outside world? So the sharing of accommodations is one factor. It's not by any means the only defining factor. In fact, the decision that you are referring to, or one of the decisions that sort of started this or opened up this discussion is that of Climens and Latner. It's an Ontario Court of Appeal decision. And in that case, it was a 14-year relationship that the parties were involved in. They did not share a particular residence. They did not hold property together. They did not have joint accounts of any sort. And they did not continuously live together in one place. But what was going on in that relationship is that, from time to time, they would share their living accommodations, where the wife would stay at the husband's cottage, or a place in the husband had a place in Florida where the wife would stay with him. And he would stay with her as well during various periods of time, whether it was for a couple of weeks or some months or whatnot. And their lives were very interwoven, and they represented themselves as couples to the outside world. The wife stayed with the husband in the hospital for, when he was having some medical issues. She ran errands for him. He proposed to her on several occasions. And when that relationship ended, the wife appealed to the courts for the courts to find her to be a common law spouse, despite the fact that she didn't fit into this traditional definition of cohabiting for an extended period of time. And the court said that, look, you know, this is one aspect that we look at, but when you look at this relationship as a whole, we do find that, you know, Ms. Climans is deemed a spouse for the purposes, in this case, she was seeking spousal support. And so it really opens up the discussion as to what, you know, cohabitation, relationship permanence really means. And for sure, when it comes to our clients, that's something that we're very cognizant of when we are asking these questions, because living together, the answer yes or no may not necessarily get us to where we need to be.
I think what you're saying is that the common sense thought process that a lot of people have in their minds of what they view as living together isn't necessarily correct. That a relationship of some permanence in common law could be established and people may not even realize it. And where I think that that's important is twofold. Number one, it becomes really important that when you're dating someone in an exclusive relationship, this is for our viewers, you may want to think about having a cohabitation agreement or a marriage contract, even though our firm doesn't do them. But you may want to think about getting that done because that may be the only way to protect you. And I often think of, can you imagine you're dating somebody for 5 years, they keep some clothes at your house, you have some clothes at their house, you spend maybe 3 nights a week together, and you take vacations together. And now you can say, well, Feldstein told you on the Ask Andrew show, I should really get a cohabitation agreement because we may be living together. They may look at you and say you're crazy, but that's where we're at. And the other place that's really interesting is the spousal support advisory guidelines we look at for the duration of a relationship. So even if people get married at 20 years, a person can 20 years of married in common law, people can be entitled to indefinite spousal support, or if the period of the relationship and the recipient's age add up to 65. So where even in a traditional case, it may be critical to determine when the common law relationship started to either get somebody to 20 or 65 or to prevent someone from getting those numbers. And believe it or not, I've had many discussions over the years with potential clients, and I don't know if you have as well, Anna, where they come into my office and they're telling me they're separating and they think they're only at 17 years. And that hastens their mindset of, I can't just keep on kicking this down the road because I don't want to be on the hook for indefinite support. So I don't know if you've had similar discussions.
Yes, absolutely. And you know, when we canvas that, and again, I find that especially in light of this fairly recent Court of Appeal decision that has come out, it's not enough anymore just to ask the question of, you know, well, how long have you guys lived together prior to marriage? Because I don't think we're getting the answer that necessarily we may require to, you know, ascertain that whether it's indefinite support or what the duration of support would be. And I think we really need to get the details very often from our clients as to what that relationship looked like before they got married. And it's not really just sort of living together. So absolutely. And you're absolutely right in what you say that people don't really think of it that way. You don't think that you may essentially be setting yourself up for, you know, an elongated support claim or potentially other claims that a common law spouse may have, because you just don't necessarily see this as a common law relationship.
Okay. And I think a lot of people are confused as to what rights common law people have. Can you tell us a little bit about what rights they have?
Sure. So in Ontario, common law partners do not have the same rights as people who are legally married. And where that's most predominantly seen is when we deal with the division of property. Married couples have the benefit of a legislative property scheme that governs upon the breakdown of their relationship. Common law partners do not. So the presumption for a common law relationship is that each party takes with them only whatever property is in their name. This often results in unfair consequences, and the courts have provided such couples with equitable remedies that they can use based on the concept of unjust enrichment. The rationale behind this is that one partner in a relationship should not be able to benefit at the detriment of another. Common law partners may therefore seek what we call beneficial interest claims in property by way of a constructive trust, resulting trust, or a joint family venture. I'm not going to get into the details and specifics of each of those claims because I don't believe we have the time today, and I can talk about this for hours probably if given the opportunity. But I know we have a lot of information on our website that deals with these specific claims, and for our viewers, if that's something that you wanted to get a little bit more information on, that's definitely a great source. But just sort of in a nutshell, if one party can demonstrate that they have made contributions to a particular property or asset which has benefited the other partner and has resulted in some sort of a detriment to them, a court may award a monetary or a proprietary interest in the property in question to even that playing field. And that's sort of the main distinction, that, you know, it's a little bit of a bigger effort that a common law spouse would have to do, and it's not as black and white as it would be for equalization and for legally married parties.
Well, I'll start with, when we talk about trust, I usually say to clients, the first assumption is the law assumes people aren't nice and generous. And in the simplest way of putting that is, if I'm in a common law relationship and I go put $2 million towards a house, and I put that house in my spouse's name, the assumption at law is I'm not such a nice guy and it's my money. And the courts start with that presumption. And the other side then has to rebut the presumption to say, well, no, that's not the case. In fact, it was a gift and you meant it as a gift. The other place we get into is something called the joint family venture, which is based on what you said as a constructive trust, and it's founded in constructive trust principles, which start with the idea that one person was advantaged and the other party was deprived of something. And to really try and simplify it, I remember one judge once said, these two people have been together for 20 years. They raised two kids together. One party stayed home. The other one went to work. It walked like a duck. It quacked like a duck. It was a marriage in every respect, but for a piece of paper. And at that settlement conference, the judge was very strong in terms of thinking, okay, if they were married, here's what the equalization payment should look like. And if you want to settle, let's give it a bit of a discount because you didn't get married. And that's sort of a practical approach. But one of the things that I would always say to people, you have to keep in mind, as part of that depends on how long were they together. And you still need to look at the roles parties play, because you may be together for 15 years, but if you're both, I'm going to give a really simple example. If you're both professionals, high income earning, kept your assets apart, or maybe you jointly bought one home and you put the same money down into that one home, but you kept your stock portfolios and your pensions completely apart, and the only thing you shared in was paying the bills of that home, you may have a much harder time at establishing the concept of a joint family venture. And the case law, there's a lot of case law on this. It's not simple, it's not straightforward. Part of it at the end of the day is a gut feeling, because you could ask 10 different lawyers whether or not you have a claim. 10 different lawyers may give you a different answer. And the other fascinating part is, just because you can establish you have a joint family venture doesn't then mean you go from getting nothing all the way to getting a full equalization payment. You have to look at it and say that the equalization payment standard, if you're not married and your common law, is the gold standard. That's the best you're going to do, that you hit the home run out of the ballpark and you got everything you wanted. And you're going to start from there to the other goalpost of saying, you're not married, you get nothing. And it's somewhere between those two places that you're going to end up if you went in front of a judge and a judge made a ruling. And the hard part is to get there for the judge to make that final ruling is really expensive. So where do the two parties reach their compromise along that plane from an equalization payment to nothing? And it may get into philosophical discussions, because I have lots of clients come in and say, the ones who have the assets, but I made a choice not to get married. I didn't want to get married because I didn't want to operate with a property regime. Well, they're right, but the courts don't view it that simply. That you shouldn't be able to be together all these years and one side gets everything. I mean, if you think of that case with a 20-year relationship, can you really imagine one person walking out of a 20-year relationship with a house and $5 million in the bank and the other side with nothing?
That's right. And I think part of, what the courts do, what the courts generally do, is they try to come up with a result that is ultimately fair, given the circumstance of a particular case. That's what equitable remedies are meant to do. And yeah, you hear both sides of the argument for sure, but for that spouse that has essentially committed themselves, him or herself, to the relationship, and now must walk away with nothing, that doesn't seem like a very fair result either, for sure. So there's.
And one other interesting nuance that you get into is that when you are married, you legally have rights to possession of the matrimonial home. And that means if your spouse wants to sell the home or mortgage the home, they must get your consent, or they have to say that they're not a spouse or it's not a matrimonial home, which would be a fraud. So that gives a very, very special right to a spouse. And in fact, Anna, what would you do when someone who's married walks into the office and they tell you, well, my spouse is on title and I'm not? There's always a step that we say to our clients, as an example, right, to protect their property rights. So,
right, for married
spouses.
Yes, of course. Yes, we ask for to register a designation very often when it's a matrimonial home. There's ways to protect our clients.
And the beauty of the designation is you're going to spend a few $100s by going to a real estate lawyer who just simply registers it on title. And it's done.
That's right.
And then if the spouse goes to sell the property, they're going to have a problem because the buyer's going to search title. They're going to see the designation, and now they got to deal with you. Now let's contrast that with what happens when it's a common law couple walks in and they say, my spouse owns the property. What are our options?
So the problem with that is that as a common law spouse, you do not have the same rights to possession that you would as a legally married spouse. The idea of a matrimonial home is a concept that is only available to legally married individuals. And so that puts us in a bit of a more difficult situation from that perspective, because a common law spouse can't as easily go to a real estate lawyer and say, please register a designation, because this is not a matrimonial home. And it doesn't fit that definition, unfortunately. So from that perspective, there are limitations for sure.
And that leads the spouse to potentially having to hire us to bring a motion for a certificate of pending litigation. And what that does is they have to be able to demonstrate that they have an interest in the real estate. So just saying, I lived common law for 5 years, so therefore I have an interest, that's not going to cut it. To get a certificate of pending litigation, you have to convince a judge that you have a real interest in that property. That means you either invested in it or have a strong enough joint family venture claim that the court's going to be willing to grant that order. So the downside is, number one, you may not get your order for certificate of pending litigation. Number two, even if you can, you have to worry about the delays at the courthouse in case your former spouse sells the property. And number three, now you're paying us to go to court. That's a lot more expensive than it is to pay a real estate lawyer who's simply going to designate the property as a matrimonial home. So those are some really critical distinctions right out of the gate that people need to understand. Because sometimes what someone does in a common law relationship is the relationship breaks down and they decide they're going to go sell the home. And they get the home, they get the cash out because the other side doesn't register the certificate of pending litigation. And what's really fascinating under the law is now that they have their money in their hands, there isn't necessarily any way for the former spouse to freeze those assets because it's not attached to any land now. So when you're married, you would have the opportunity to put the designation down. When you're married, you have the opportunity to bring a motion before the court to have a non-depletion order, meaning to freeze people's assets or limit the ability they can use their money if you're concerned about your equalization payment. When you're common law, there's no equivalent to freezing your assets, freezing the other side's assets for the purposes of property claims. It's only for the certificate of pending litigation. And that's all based on the definition of spouse. So there's some really, from a lawyer's perspective, it can be academically interesting. It can be fun to do when you see a case and the other side says to you, we want your client to agree not to deplete his assets, and you write them back, please give me your legal authority for doing so, as the home has been sold now and my client has the cash, and they can't do that.
That's right.
Whereas if they were married, they would be able to do that. So there's some really significant differences. And for our viewers, you need to be aware of it. And it's a good idea to consult with a lawyer before you really take any steps, because you're putting yourself at jeopardy. Now, I'm going to switch over to another line of questions now, Anna. We know that married couples may be entitled to a marriage deduction upon separation for the assets or properties they brought into the marriage. What advice would you give to a common law person who wants to protect their assets when they move in with someone, whether they knew or didn't know if they're moving in with someone?
Right. I mean, the best thing that we can recommend, again, we don't do them here, but the best thing that we can recommend to, our potential clients or anybody that I speak to that is looking to, enter into a serious relationship, get a contract together. Similar to a marriage contract for married couples, you can have a cohabitation agreement for common law couples and set out what each of you intend this to look like, what each of you would expect upon a separation, so that there are no surprises. Because at the end of the day, there is a document that at least, both of you can go back to and say this was the intention of the parties. These agreements, whether it's a cohabitation agreement or a marriage contract or even a separation agreement, they're not bulletproof in the sense that they can be set aside by the court in the future. But even then, there are certain things that you can do to mitigate, the potential scrutiny of the court, such as, exchange full financial disclosure before you sign a document of this nature. Have both parties each obtain their own independent legal advice. These are things that will make this agreement more resistant to being set aside. So it's better than not having anything, because if there's nothing there, then you're open to all sorts of potential issues and surprises, and the law evolves every day. So, just like with this Court of Appeal decision that we spoke about earlier, prior to that decision, I'm sure most lawyers would say that, a regular, consistent cohabitation in a certain property was a prerequisite. That was clearly not the case as the Court of Appeal had decided. So your best bet is really to get a contracting gear, get each of your positions set out. That's really the best protection that you can have at this point.
And what I would say is a lot of people are going to be nervous to go ask for a contract. Most people are. It's much easier to ask if you're on your second relationship, so that if you have children from a prior relationship, you have significant assets you're bringing in, it is easier to ask than when you're getting together and you're 20 something years old and you both have nothing. That's a much harder ask than when you're 45, 50 years old and you have kids and you have something. So the other thing I will add, in addition to a contract, is I will tell everyone they should get a contract. But if you're not going to get a contract, which may be the next question, what's the best thing to do? The best thing to do is to keep a record of all of your assets. So when you get your bank statement, your RSP statement, your investment portfolio statement, the smartest thing you can do is at least once a year, download all your statements, save them somewhere in the cloud where your partner does not know your password. Because if you ever get married, or if there's ever this dispute, you'd like to have the bookends to know what you had when you got together. Because remember, earlier on in the show, I said the best day, the absolute best day that someone can get is them saying they should be treated the same as a spouse. Well, if that was the scenario, then you're looking at what did you bring in the relationship? And most people don't have proof of what they brought in the relationship. So make sure, even if you don't know when you started to live common law, just if you think it's a maybe, download these statements, save them in the cloud. Don't put it somewhere where your former spouse can destroy it, because I can think of how many times I've had clients come into my office and they say, I had these assets on the date of marriage. I know where the bank statement is at home. And I tell them, okay, go get copies of those statements. They're like, no problem, Andrew. I've had $500,000 when we got together. And they go back home. And then they phone me a couple hours later and they say it's not here. And is it really a surprise that your former spouse knew that by going into your filing cabinet, taking out a couple pieces of paper and putting it in the shredder, they can make $250,000 after tax just like that? It really isn't. And I can tell you, when I got married to my first wife, I should have gotten a marriage contract. I knew better, but I was young. I was still in my 20s, so I didn't do it. But at the very least, I was smart enough that I took all my portfolio statements, the financial statement for my business, and put it in a safety deposit box that was solely in my name. So when I separated, even though I didn't think I'd ever need it, I had all the documents to support what I had on the date of marriage. Remember, my ex was frustrated that I was able to prove it, but it's the alternative. It's not the best route. It's not a great route, but at the very least, you can prove what you have. Because I don't know about you, Anna, how often do you see people 15, 20 years later actually being able to prove what they brought into the relationship?
Not very often. Not very often. And again, it might be, we do this for a living. So we see sort of the worst of marriages that may be out there because, these marriages have broken down. So we're fairly pessimistic and to the process maybe. So we're always thinking about how to protect. People that are entering relationships are not thinking that way. They're thinking about a beautiful life together. They're thinking about, happiness, children, and whatnot. That's not where their frame of mind necessarily is. You happen to be a lawyer. That's why when you got married, even the first time, you were at least able to ensure that those documents were there. But most people will not. They just, that's not where their mindset is. That's not what they're thinking about at the time, unless you are in this profession or have had an experience with, whether it's separated parents or separated siblings or whatnot, that you would know about something like that. But I think it's very important because you never know where life may take you. And, we all hope that our marriages will be successful and wonderful, but that's unfortunately not always the case.
And that's correct. But we're trying to give advice to people that if they're hearing this, or information, I really should say, we're giving them information to give you the tools that if you don't want to ask for a contract, here's something you can do to at least protect what you do have. Not the best, but it's something to protect what you do have. Now, I'm going to ask you one last question. This is one I get all the time from people. They say, I'm married, I'm separated now. Can I live with somebody else at the same time, or is that polygamy?
Right. So you can live, once you're separated, you can start new relationships. You can live with somebody. It's not deemed infidelity. It's not deemed polygamy. You're able to be in a common law relationship. You're able to be in a cohabitation. You're able to be in whatever relationship you would like at that point in time. If you wish to remarry, however, you will need a divorce. So that's really the prerequisite. If you want to remarry, you do not need it if you wish to cohabit.
And I should add, there's lots of people that have been separated sometimes 10, 20 years, never get divorced, and they're living with someone else. There is nothing wrong with that. There's nothing to be ashamed by, albeit I know some people like to say, I really don't feel like living with somebody who is technically married to somebody else. I understand that. That's not an uncommon feeling, but it's reality. Anna, I wanted to thank you very much for being on the show today. It was a pleasure having you.
Thank you for having me.
And the next Ask Andrew show will be May 17th at 12 noon. If you have any requests or ideas for future shows, please email us at info@feldsteinfamilylaw.com. And thank you for watching.